Okay. Good morning, everyone. I'm Amy. I use she, her, hers pronouns, and this is a really exciting episode of Quarantine that we're bringing to you because we are talking with two people from LawNY York who are going to be talking with us about fair housing and what that looks like in New York right now. And our question of the week is, what is our favorite spring activity that we're looking forward to? Because the sun is back, the rain has sort of subsided for now, and flowers are starting to grow. So we're all very oriented toward being outside doing spring things. So my answer would be we get to go camping now. My partner and I just went camping over the weekend, and we've already booked like 3 more camp trips for the next coming months. So we're very excited about that.
I'm Mitch. I use he, him, his pronouns. I am the other program coordinator here with Family Counseling Service of the Finger Lakes. And my favorite spring activity, besides being in the garden, which I love, is just going for walks in the woods and seeing the leaves start to come out and the wildflowers start to come up. It's really fun to kind of keep tabs on like the different ones. Like the bloodroot is out now if you're looking for it, and that's one of my favorites. I'm looking forward to the trillium being up very soon.
Hi, I'm Mary Palermo. I'm from Legal Assistance of Western New York. I'm a fair housing education and outreach paralegal here. And I use she, her pronouns. And one of our favorite springtime activities is finally getting to take the kids and the dogs for a walk because they really enjoy going on those long walks. And of course, my husband loves polka hunting. So we're always out walking around town, seeing everybody.
I'm from Legal Assistance Western New York as well. I'm a newly admitted staff attorney. I use he, him, his pronouns, and the springtime for me always means a return to the rugby season. I do play rugby. It's a little tricky right now, as you can all imagine, but we are trying to do it safely. So that's been fun to add that back into my life.
Is that a local league that you have here?
So there's actually geographical leagues. The Northeast is one, and then there's actually national tournaments, but I do play for a team out of Buffalo currently.
That's so cool. Mm-hmm. Right on. So we just wanted to talk with you today. This is less of an interview, more of just a conversation. We know that some laws are starting to shift as the pandemic is sort of finding its stride. People are becoming more vaccinated. We know that things are shifting. So we just wanted to talk with you today about what people's rights are in our state, what things we need to be keeping an eye out for, and just sort of how the tides are shifting as we open back up. So I'll go ahead and open that floor. Mitch, if you've got any questions you want to ask specifically, go for it.
No, I'll just let you take it away, Mary.
Absolutely. So I'm going to be mostly talking today about the Federal Fair Housing Act. It is a national law, so it does cover everybody in the U.S. I will touch on New York State laws because they are just slightly different. And then Colton can touch on the eviction moratoriums and some other housing issues that he definitely knows more about than I do. So under the Federal Fair Housing Act, people involved in housing transactions, so this could be whether it's a rental, sale, or purchase of property. It's anybody from a landlord, that's one of the main actors that we see, but it can also be financial institutions, banks, municipalities, like maybe you have municipal water or something like that. It could be insurance companies, if you're getting renters or homeowners insurance, literally anybody that could be involved in a housing transaction has to abide by these laws. And so this law affords protections where they can't discriminate based on a person's race, color, religion, national origin, sex, disability, or their family status. And so when we're talking about race, we're talking about somebody's biological characteristics, whether they're Black, white, African American, Asian, like whatever it may be. Their color is actually the color of their skin. And so this is whether, maybe a landlord's going to say, your skin's really dark and I'm just afraid that you're going to make our other tenants uncomfortable or something like that. Religion is somebody's either their religious beliefs or their affiliation with a group or religious institution. their national origin is their national origin or their ancestors' national origin. And so we may see this like if they're an immigrant, or maybe they're children of immigrants, or their great-great-grandparents were immigrants, but they still have very strong cultural roots to their national origin. They may be discriminated against based on that. Disability is, generally speaking, it's when you have a mental or physical disability that substantially limits one or more major life activity. And so that's essentially like if you have something that affects your talking, hearing, seeing, eating, breathing, working, learning, literally anything you have to do to like live on your own, that could be covered under disability. So it's not always like I need a wheelchair, or I'm deaf, or I'm blind. It could be, you know, you have PTSD, or some other mental health issue, or some other diagnosis where it impacts the way that you learn or the way that you understand things. Maybe you need things explained in a different way, or, you know, it could be minor things. It doesn't necessarily need to be like, I need a wheelchair or a hearing aid or something like that. And familial status generally refers to families with children that are under the age of 18. And so this is whether it's your own biological child, an adopted child, you're going to be getting custody of a child, maybe it's your grandchildren, or you know, maybe you have a placement through the court where it's not actually your biological child, but you have custody of them either temporarily or indefinitely. They can't discriminate based on that. And then the big one that I wanted to mention was sex. So this category of sex actually encompasses quite a lot of different things. And so not only does this cover gender discrimination, but it also covers gender identity and sexual orientation. It also provides rights to domestic violence survivors. And it also affords protections to protections against, I should say, maternity leave discrimination and also sexual harassment. And so I'm going to talk about each of these a little bit more. So when we're talking about sexual harassment, it's sexual harassment from anybody in this housing process. So say you live in an apartment complex, and there's a property manager, you have maintenance people, you have the landlord themselves, you know, maybe there's contractors that are working on the house or apartment or whatever it may be. None of these people can discriminate or sexually harass you based on this protected class. Also, maternity leave discrimination. Sometimes we see like people don't want to rent or sell to somebody because they're pregnant and going to have a baby, or they are on maternity leave because they're afraid, you know, we don't have paid leave in this country. So they're afraid, oh, you won't be able to pay your rent. You're not going to pay your mortgage. Like, I don't want to go through that. So they just won't rent to you. They can't do that. It's illegal. And domestic violence victims and survivors actually have a really, really nice protection here, because the landlord can't evict them because they were a victim. They can't evict them because they had the police called for domestic violence incidences. They can't, you know, refuse to renew a lease because of that, because of any of these things. They can't try to evict them because they had noise complaints from other tenants that were associated with domestic violence incidences. They can't refuse to take somebody off the lease or refuse to break a lease because of these things, because it's a violation of this federal law. And this is a good point to know. This law not only protects people that fall into any of these categories that I've mentioned, but also protects anybody that's perceived as, or anybody that associates with others that fall into these categories. So maybe, you know, maybe I'm straight, but I have my best friend who's trans, and she goes with me to go look at this apartment. And the landlord's like, I don't rent to people like you. Well, you know, I'm not trans, but they just discriminated against me because my friend is, or because maybe they think I am, or whatever. So, you know, that's illegal and it's not allowed. I'm going to touch on New York State protections. I'm going to touch on what you should do if you experience any of this and kind of what it could look like, because it's not always going to be, oh, you're trans, I don't want to rent to you, or, oh, you have kids, sorry, I don't allow kids here, or
Right.
sorry, you can't have your service animal. It's not going to be that obvious. So I'm going to talk about some of the like tricky ways that landlords and others kind of discriminate discreetly now, because they know that these laws are out there and they know that they're violating them. So they find crafty ways to like.
Unfortunately. I just, real quick, I had a clarifying question. So you mentioned contractors. So I'm thinking like in terms of if you're living in a rental community, would that contractor have to be employed by the person you're renting from for you to be protected if something happens discriminatory with the contractor? Like if you were a homeowner, I'm thinking, for example, and you hired a contractor to work on a property you own, would that be different than if it was a contractor employed by a rental company?
So generally when we're talking about the sexual harassment discrimination, we're thinking like, so landlords have to give you notice to enter your property. It's usually written into your lease. They can't enter without permission. They have to give you notice, whatever. So if the landlord's constantly in and out of your apartment without notice, that could be considered sexual harassment. So similarly, if they have a contractor that's going to come in to fix things and they're constantly in and out without giving you notice and without, you know, getting your permission, that could be considered sexual harassment. If they have a contractor, so if it's a landlord that has a contractor that, you know, maybe they're only going into one specific apartment repetitively, or a group of apartments, and all of these apartments are rented by single parents or by single females, like that could be sexual harassment. Generally, if you own your own home, you're dealing with the contractor directly, so they have to have your permission to be able to enter the apartment. Usually there's not somebody else that like has a key that can just let them in. So usually when we're talking about contractors, we're looking at like apartment complexes where the contractor is employed by the landlord, the rental company, like whatever it is, because they have the ability to let somebody else into your living space.
Gotcha.
So, I mean, could it happen with a contractor when you own a home? Probably it could. Is it likely? Probably not, because you're going to have to let them in or, you know, give them a key with permission to enter your space. So I don't think we've seen it with a homeowner. Usually this comes up more with like rental properties because there is somebody else with a authority to let people in. That was a good question though. So I went over the federal protections, which is race, color, religion, national origin, sex, disability, familial status. New York State has some expansions on this, and some of them did change about a year, maybe a year and a half ago. And so this includes sexual orientation, which we actually got HUD guidance, and now the federal law protects against sexual orientation discrimination, which is wonderful. But New York State also has military status, marital status, age, and lawful source of income. And so when they're talking about military status, sometimes we see where landlords don't want to rent to people, or financial institutions don't want to give somebody a mortgage because maybe they're not active military, they're reserves, National Guard, whatever it may be, but they're afraid that this person's going to get called to duty, or they're afraid that they're going to be deployed. And then they're not going to be there, they're not going to make their payments or make their rent, whatever it may be. So they refuse to rent to them. That's illegal under New York State law. Marital status, sometimes we see places, you know, that say, oh, females only, or single females only, or you know, we prefer couples, or families preferred, or families not allowed. So, you know, that marital status could be an issue and could come into play sometimes, and it is illegal to discriminate based on that. Under New York State law, when we're talking about age, we're talking about people over 18. And I'll talk about this a little bit more when I get into how to spot discrimination in just a minute, because I have some examples where age may come into play. But the newest change was lawful source of income. So I'm sure that if you were looking for apartments even 5 years ago, you would see tons of ad that said no Section 8, no DSS, whatever. They can't do that now. So under New York state law, they can't discriminate based on a lawful source of income. And so DSS assistance, Section 8 vouchers, child support, literally any lawful source of income aside from like wages, and it includes wages, they can't discriminate against. So they can't say, oh, you live off of that anymore. And so that was a really big change in New York state law. So going back to age a little bit, and this is kind of how landlords can be a little tricky. So sometimes landlords will have different amenities, policies, services, sometimes they have different rates for people based on a protected class. And so they'll say, oh, you're a college student. College students are usually like, 18, 19, 20. They think they're not really responsible. They're going to say, you need double security deposit. Where if I went to go rent it, I'm getting close to 30 now. If I go to rent it, they're going to say, oh, yep, security deposit, first month rent, like that's all you need, you can move in. Having that different policy where they're going to charge somebody else, a double security deposit, or tell them that, oh, sorry, you won't have access to the laundry facilities, or maybe you won't have access to the pool, or we don't allow kids in the pool, or, just having those different things available to people could be discriminatory. And, maybe they don't realize that if I go in and they say, yeah, this unit doesn't have access to the pool, or it doesn't have access to the laundry facility, I'd be like, oh, okay, whatever. But if I send my friend in and then they tell my friend, yep, this has access to everything. Well, I wouldn't know that they told my friend that unless I talked to that person. So sometimes landlords can like try to dissuade you from renting here, or tell you like, oh yeah, are you sure that you're going to be comfortable here? Like maybe you'll be comfortable in a different neighborhood or in this different apartment, or whatever. So sometimes they like try to steer you, and that's not allowed. Realtors can also steer people either to or from certain properties, certain neighborhoods, whatever it may be. And we also see a lot of like, I'll call and say, hey, I'm interested in this apartment or this house. Like, can I come look at it? Is it still available? The landlord or seller will say, yep, absolutely. But then you have somebody who has a Hispanic accent, or I'm trying to think of other examples over the phone. But so anyway, if you have this person that like has a Hispanic accent that calls and they're like, yep, nope, not available, sorry, that's discriminatory. Because they're giving false or misleading information to people based on their protected class. This also could happen, maybe you sound white enough and the landlord doesn't realize that maybe you're of a different race, or you have different religious beliefs, or your skin color is not as white as they were expecting. And you show up to look at it and they're like, oh yeah, sorry, I just rented it, because they see you and they're like, oh, I don't want that here, so they discriminate. That could happen. We've seen that happen. And so these are all issues that could come up in the fair housing world. Now, the fair housing laws haven't changed a whole lot during quarantine or because of quarantine. The biggest change, honestly, for us was the new HUD guidance that expanded the sex protections to include not only gender, but gender identity and sexual orientation. So before we kind of had to rely on New York state law, but now it's actually federal law that's been changed. So that's the biggest change for us, but I know that there are eviction moratoriums and they're really confusing, and there's a couple different ones out there. And so I'm going to invite Colton to talk a little bit about that because he definitely knows more than I do.
I just have one really quick question clarifying. So you had mentioned that a lot of banks aren't willing to give loans to people who are veterans, who are reserved. Are there, so I know that when you're buying a house, there's like a specific VA loan that veterans are qualified for. Are there things that are set up as protections for, or maybe able to give money to active military or reserves who are not buying a house or renting, but are sort of being discriminated against?
You know, I'm not entirely sure on that, to be honest with you. I don't necessarily deal a whole lot with like sale of property transactions, so I'm not sure. I don't know if Colton knows, but there might be other protections and money out there.
Thank you.
Thank you. And Amy, I'm not quite sure on your last question there either, but I can definitely get into some of the eviction information. And like Mary alluded to, it's been pretty confusing since the start of the pandemic. Thankfully, mostly in a positive way, it's been confusing because it's prevented a lot of people from being evicted. But just generally, I'll go over in the before times, there is basically two types of evictions, and those continue now. Non-payment evictions and then holdover evictions. A non-payment eviction is basically your landlord saying you haven't been paying rent, I would like you out of the property. Whereas a holdover eviction is saying that your lease term is up, or on a month-to-month basis that you've been renting, they give you the proper amount of notice and say, after this either 30, 60, or 90 days, depending on how long you've lived there, I would no longer like to rent to you. And so that's important because these different protections might only cover the non-payments, while the New York protection that I'll get into in a second does cover both at the moment. So from there, basically, I guess I'll start with New York. There are two New York laws that currently have some protections for tenants. The first was the Tenant Safe Harbor Act, which was put into effect very early in the pandemic. And basically the way that works is that this one doesn't really stop court, but what it does do is it prevents a landlord from being able to evict a person if they've suffered financial hardship during the COVID-19 pandemic. If they've lost income during it, if they've had financial hardship, by the way, that's how law defines it. And then what it prevents is the actual eviction. It doesn't prevent the court proceedings necessarily. It did for a while, it doesn't any longer. And it doesn't prevent a money judgment. Sorry, Mary, you trying to?
Yeah, so I just wanted to mention here, like the general eviction process, because a lot of people don't exactly know, like, what does an eviction look like? They think that they just get papers and then they have to move out. So there's actually a process where the landlord has to file a case in court. You have to be served with official court papers. Once you get those court papers, you go to court. In New York State, there is a 14-day, you can request a 14-day adjournment. Any party can request this. Anybody is entitled to it. So if you request that adjournment, you go back in 14 days. After the 14 days have ended, the court can then hear the case. And then they make a decision. So if they agree with your landlord, then they can sign an eviction warrant. And once that warrant is signed, then it has to go to an officer. They have to officially serve it on you. And so it could be personal service where they actually hand it to you, but they also can nail and mail, where they affix it to your property, and then they have to mail you, I believe it's a certified copy, right, Colton?
Yeah.
So they have to mail you that certified copy, and it needs to be certified. And then you have, I believe it's 14 days after that occurs for you to actually move out. And if you don't move out before the 14 days time, the police can come back and remove you and your belongings. Your landlord can change your locks. So when Colton was just talking about how you can go through the court process, but they can't actually evict you. He's talking about they can go through and they can sign the warrant, but they can't actually like remove you, serve that warrant on you, and actually execute it, which is the at the end of that 14 days where they can actually change the locks and kick you out. So I just wanted to clarify that before you went on, because that might be confusing for some people that just aren't familiar with the court process.
No, thank you. That's very helpful. I should have started back a little bit. And just to add on to that a little bit, so the big takeaway from there is you can't be evicted, physically removed from the property until this court process happens, right? You know, your landlord can't just serve you some type of notice and then come and try to remove you. Actually, just as a quick side note, if a landlord does do something without going through the court system, that would be an illegal eviction. That can take many forms. It could be some type of intimidation. It could be turning off your utilities, it could be locking you out physically. It could be trying to, short circuit the court system and just, like physically showing up with an officer. But until you're served, like Mary said, with the warrant of eviction by an officer, you cannot be evicted. And so going back to those protections, like I was talking about the Tenant Safe Harbor Act, that's a defense you would have to raise. And so that one only applies in the non-payment proceedings, the ones where the landlord's trying to say you haven't been paying your rent. And so that one lasts. So it's the financial hardship period, lasts from the beginning of the pandemic, so last March, up until in your county, any protections, any restrictions on business. So, currently I believe restaurants still have a 10 p.m. curfew, I believe. So anything like that, if it still exists in your county, then that covered period is still happening. And so from what I understand, it is still happening all around the state. And that's one defense that you would raise. It does not prevent you from receiving what's called a money judgment. So just briefly, in non-payment eviction proceedings, there's generally two different prongs to the order. One, a possessory judgment, which says the landlord can reclaim possession of the property, and then also an order for the amount of money that they allege that you haven't been paying. And so it doesn't prevent the money judgment, but it would prevent the actual eviction for any money that became due starting at the beginning of the pandemic up until, like I was saying, these restrictions are lifted, which I don't believe they have in any county, all the way. And then the other protection in New York specifically comes from what's called the COVID Emergency Eviction and Foreclosure Prevention Act that was passed just after Christmas of last year, right before the new year. And what that did is it put a 60-day stay on any pending eviction cases, including holdovers as well as the non-payments. And so that went until February 26th. There were no court dates in evictions for those, except for a very narrow set of cases where the landlord was alleging that a tenant was some type of nuisance, and that nuisance was affecting other tenants, right? So if you lived in a single family house that you were renting, or if you were the only person in a two-family house, if you were the only person there, that probably wouldn't apply. But if you were in an apartment building and the landlord was alleging some type of nuisance, then they would have been able to go forward. But that's a rather narrow set of cases. And so that 60-day period ended on February 26th. And then what the law also did is it provided the opportunity for tenants to submit a hardship declaration, which would further that stay until May 1st. There's a possibility that this may get extended. However, there hasn't been anything official as of right now, but you qualify for this declaration, and it can be found on the New York State Court websites, or if you just simply Google New York COVID Hardship Declaration, it should come up. The first set is that you are experiencing financial hardship, and this can be a significant loss of household income, an increase of out-of-pocket expenses due to performing work, or any health impacts during the pandemic. If you've had increased expenses or a harder time being able to go out and work because of increased childcare. A lot of children are home from school right now. or having to care for elderly individuals, disabled or sick family members. That could be one reason. Another reason is if you have, if moving expenses are prohibiting you from, being able to find new housing, or if you've been able, even if you do have the money, if it's hard and you've been looking and haven't been able to find a place, that's another reason that you would qualify for this declaration. And then also, if you have certain health conditions that make you more susceptible to adverse health effects from COVID-19, that's another reason you may qualify. And then, like I said earlier, this one applies to both the non-payments and the holdover evictions. And then, so the stay would therefore, if you do sign that, and I want to clarify this, so it doesn't automatically apply to someone. You do have to fill out the declaration and either submit it to your landlord's attorney, or you can submit it directly to the court. If you haven't done so, then your court case can proceed, and they have been proceeding throughout the state for people who haven't submitted these hardship declarations. And so if you think you might qualify, you should really look into that. And then what the hardship declaration also does, and this is a little tricky, is that for that Tenant Safe Harbor Act, the financial hardship, you have to prove that in order to get that protection, right? And that's the one where you can get the money judgment, but can't get kicked out. This declaration under this other New York program creates a rebuttable presumption, which basically is saying, like, I filled this out, and this means that I do have a financial hardship that would qualify for that Tenant Safe Harbor Act protection. And then it would be the landlord's burden, right? They would have to go to court and allege specific facts to rebut the fact that you're having a financial hardship. And I can get back into that if you have any questions on that. But I did want to move, because I'm sure a lot of people have heard about it. There's also this CDC moratorium, which was recently extended through June 30th, 2021. The CDC moratorium is a little different than the New York protection. The criteria to qualify are different, and it only applies to non-payment cases. And so you have to have been having financial hardship due to the pandemic, and there's a declaration for that one as well, and you have to attest to the fact that you have been using your best efforts to either find new housing or to get government assistance to pay for your housing. And then also you'd have to attest to the fact that you've been making rent payments as much as you can. These are all fact specific for each person, and it would be different in each case, and you'd want to talk through that with an attorney if you can. And then also that you'd have to attest to the fact that if you were evicted, you would be rendered homeless, right? And so it's got slightly different criteria than the New York one. And then those protections also don't include the stay in the case. It's more like the Tenant Safe Harbor Act, where the case can go forward, but you can't be evicted until the end of the period, right? So if you were to submit the CDC declaration, if you qualified, you wouldn't be able to be evicted until after June 30th. But from what I understand, the case could still go forward. It doesn't have that stay like the New York CEFA, the COVID Emergency Eviction Foreclosure Prevention Act. So in that way, they're a little different. And as of right now, those are the things that are keeping, that are dictating what's happening in the courts. But also recently passed in the New York State budget, I believe last Wednesday, they've more formalized what's known as the Emergency Rent Assistance Program. This is something that came from federal funding, and then the state was given money, which was then doled out to municipalities in order to pay back rent. And so these programs are still getting set up in most municipalities, from what I understand. And Mary, you might know a little bit about these, maybe.
Yeah, so I've heard about the emergency rental assistance programs, the ERAs. I had checked the HCR, the Homes and Community Renewal website, who was previously administering this program. they just direct you to a different website to look at. So far, I don't think any of them are set up. I think they're still in that process because it is still fairly new, and it takes some time to get it set up. But when I had talked to some of our other coworkers about these, he had suggested that, if you are facing eviction, or, somebody is facing eviction, check with DSS. They may be able to assist depending on what the amounts are, but also look into these rental relief programs because they may be able to pay that back rent for you. But I don't think any of them are fully set up and running yet in any of the counties that we serve, at least not that I've heard.
Yeah, I know that is very in a similar vein too. There are a couple from the latest COVID relief bill that just went through. There are a couple federal funding provisions that are coming down the pike here. They just haven't set up the protocol or how they're going to dole that out yet. But we will be having you join us for Finger Lakes Pride in June. And so my hope is that maybe by then we know a little bit more about how those programs are going to work so we can share that out. Because I think I've heard that, and as well with the funeral cost reimbursement, I know they're still setting that up as well.
Yeah, I think sometimes it's just going to take a little bit more time to get these programs fully formulated and set up so that they can effectively get money out to people.
Mm-hmm.
But this conversation actually brings me back to another point that I failed to make earlier in the presentation, in this discussion today, when I was kind of giving information about the Fair Housing Act and what is discriminatory and illegal. I didn't talk about what people should do if they've experienced this or if they know somebody that's experienced this. So there are a couple different things that they can do. And the first thing that they should do is to tell somebody, gather any proof that they have, contact an attorney. I know that right now Legal Assistance of Western New York does have funding through HUD, where we are able to investigate and litigate housing discrimination claims. We also have a grant through New York State that we're able to do the same thing. But they can also file complaints. So the Department of Justice has authority to enforce this law, and so does HUD. And so they can make a complaint. You can also go to court over it, but sometimes it just needs some like nudging to the landlord, like, hey, what you're doing is illegal. You can't do this. That doesn't always work. Sometimes it does require a court case. But the great thing about the funding that we have and the programs that we have is we're able to investigate this. So if somebody thinks like, that didn't seem very, that seemed kind of off, or maybe there's like, you're just getting a bad vibe from this landlord. So like my example earlier where you call and you sound white enough, but you show up, or you sound straight enough or whatever, and you show up and they're like, yep, nope, sorry, it's rented. You're like, well, that's kind of weird because on the phone, you just told me it was available, but now you see me. So like, even if they don't have the hard proof that this person discriminated against them, we have the funding through HUD to be able to investigate that and see if there is discrimination and see, if there's something we can do about it. And even if we can't find discrimination, now we might have found discrimination with this landlord in the past, or we might be able to suss up something to like prove it. So even if the person doesn't have proof and it's maybe just a hunch or a feeling, it's definitely worth a call because you never know what's going to come of it. But if they don't want to get an attorney involved, that's fine too. They can definitely file their own complaints through HUD. And there's also state complaints if it's a state protection that they violated that they can file too.
Right. That was a thought that I had. I went and made a little note for myself when Colton, you were talking about the two different kinds of evictions. One of the first things I thought of is with the holdover evictions, up until 2020, when we started getting these state protections that included gender identity, gender expression, and sexual orientation, before that was explicitly stated as actual or perceived, we know very well that people would oftentimes come out and then suddenly their landlord wasn't going to rent to them anymore. And so for these holdover evictions, what I was wondering is if I, for example, as a transgender person, were just coming out and starting my transition, and my landlord turned around and gave me a 60-day holdover, I want to rent the property to somebody else. Do they have to show some kind of cause for that? Or like what pretense would someone have? Because it's very difficult in a lot of these insidious discrimination cases to pin down that, oh yes, they said something to me, that it was because I was transgender, rather than I asked them to call me this different name and now I'm getting this 60-day notice a week later. So I was kind of wondering if I could pick your brains on that and what someone would do in a situation like that, because I guarantee you it has happened.
So what I'm going to say as far as the state and federal fair housing protections, if something like that does happen and they think like, oh, it's because I'm trans and I came out, or, you know, even if it's not that, if it's any of the other protected classes too, they should definitely reach out to somebody. There are agencies all across the entire US that do the same type of investigation process that we do to suss out this discrimination. And at least for our organization, we save anytime that we have like a positive test, we will save it. So even if we can't prove it with this person's case, we might be able to pull up a test from 10 years ago that was like, oh, the same thing happened. Oh, look, this like we can show those patterns. Sometimes we don't always have that evidence to back it up, but we might, you never know. But I think that investigation piece, which HUD funds, is really important, because you're right, it is hard to find. It is hard to pinpoint, like, they were overtly, blatantly discriminatory against me. That doesn't happen often. Sometimes it does, but being able to show these patterns sometimes could be sufficient to show discrimination. Colton, do you have anything to add to that as on the like eviction side of it?
Well, and then just unfortunately to touch on Mitch's question about cause, landlords aren't required to give a reason. They're just required to give, you know, the necessary amount of notice. And so if you haven't been living there very long, that could be as short as 30 days. If you've been there for over a year, 60 days, and then more than 2 years, 90 days.
So I have a question specifically relating to protected cases and sort of how to go about talking to a landlord or filing for assistance. So I know you had said that disability is something that's covered and domestic violence is something that's covered. A lot of times we see, especially in the work that we do, that disability takes on the form of having really bad mental health, having really severe trauma, PTSD, things like that. So for our clients who may say, you know, I'm going through this situation, here's what's going on, but are really afraid of having to re-traumatize themselves and telling their stories over and over again, or, you know, mental health and domestic violence in particular are two very, very strictly protected classes through HIPAA in our state. So what would your advice be, or sort of thoughts be, around helping our clients get the justice that they need without re-traumatizing themselves, or having to be forced to give over this information that maybe their landlords don't have the right to have, but because clients may not know their rights, they feel they have to be giving this private information over?
Right. So that's a really good question. And like you said, there are protections. You know, obviously, like if I get in my position, if we get protected information about clients, medical information, we can't then go share it with other people because of HIPAA. So unfortunately, if you can't get your client's consent to, you know, talk to other people or discuss these issues, you're kind of stuck, because you can't force them to get help if you think that they need the help. However, if you do have clients that have mental health issues or victims and they agree to seek that assistance, that's the first step, is agreeing to seek the assistance, but then you can reach out to other agencies. So like I had mentioned earlier, Law New York does have the funding right now in the counties that we serve to do what we call light advocacy, which could just be reaching out and like nudging the landlord, like, hey, you're doing something illegal, all the way up to filing a federal court case or a state court case. But that being said, I know that it can be traumatizing to go through and retell their stories and stuff. Unfortunately, that's information that we would kind of need to go through, like figuring out what we have to do. But once we have that information, say for example, somebody has some type of mental health issue and it impacts their ability to live. And so maybe they need some type of accommodation or modification to general policies. So I'm thinking, like, for example, if somebody has a mental health problem and they need like a support animal or something, the landlord has a no pets policy. Sometimes getting a letter and a sufficient letter from a healthcare provider saying, hey, this person needs this animal, and the letters don't necessarily need to be incredibly in-depth, although having like supporting information is definitely helpful. But we can, like, getting that assistance to make a request for a reasonable modification or accommodation, depending on what the disability is and what they need, can get them the services they need or get them the assistance they need or whatever it may be. So unfortunately, without having that client's permission and without being able to have them retell that story, it's kind of hard to do these things. But once they are able to do that or they agree to these things, there is help out there for them. And as far as the domestic violence stuff goes, I know that can be really traumatizing to like talk about it again, and even to just admit like I'm a survivor and this is what happened, can be really hard. But there are a lot of protections out there and a lot of things that they can do to make the situation better and prevent it from happening again. And prevent the discrimination based on it, like the evictions, or sometimes they get harassed because they've had cops, there, and then the landlord starts, bugging them about that. That could be discrimination under the Fair Housing Act too.
So if a client who experienced discrimination, speaking to a whole different world, when I am working with youth who have been bullied or harassed in school, I am a strong believer in the Dignity for All Students Act, and I actually have youth who make those reports keep copies for themselves. So what I'm wondering then is, what should we recommend to our clients who are DV or other like crime impacted, instead of having to reshare those stories verbally, would having that documentation give the information they need to like lower the risk of repeating, like lower the amount they need to talk through?
Yeah, so definitely any documentation or information that they may have, whether it's from, a police report or medical documents, whatever they have that may tell a fuller story without them having to relive that experience and tell it themselves, is always helpful when you're looking at, how can we help you? Can we get you a modification or accommodation? Can we get this person off your lease? Can we, like, is there an order of protection? Even so, speaking of orders of protection, sometimes court documents could be helpful too if they have anything related to that. So definitely any documentation that they may have about their experiences or about their mental health or their physical or mental impairments definitely could be helpful going forward in getting these protections in place for them.
And just for clarification, you said earlier, but I just want to make sure we reiterate, if somebody perceives that they have been discriminated against, but they don't have the cold hard, like, nope, you're trans, and I don't agree with that. Your recommendation is to still reach out to file some sort of complaint and sort of see if you can make that paper trail. So that even though it wasn't flagrant discrimination, there is still potentially a path to take for justice.
Absolutely. So we've had clients, call our office and be like, hey, I think I might have been discriminated against, but I'm not really sure. And then from there, we're able to, if we think it's something where there might be discrimination, we're like, oh, okay, we can go and investigate this and see, oh yeah, look, the landlord definitely discriminated because here's this proof that we gathered. So even if your clients or people that you're working with don't have the proof and they just have like a hunch or a feeling, definitely reach out, because we may be able to gather that proof, or another agency may be able to gather that proof to show like, yeah, there really was discrimination here.
Great, thank you so much. Was there anything else that you felt we really needed to sort of get across to the people watching this, or is this, I know we've got a lot of changes still coming, and we're going to be talking to you again in about a month and a half, so we're really excited to be able to have this conversation again, especially because at that point things will have settled a little bit differently. But I can't tell you how much we appreciate having you come on and talk about these things, because a lot of people don't know how to know their rights. And it's incredible work that you do. And I love that we're able to bridge our gaps in services to come together and really serve our community. So I just wanted to say thank you so much. I don't know, Mitch, if you have anything else you wanted to add in there, but we really appreciate you taking the time to talk with us and let us help our clients to the best of our ability.
Absolutely. I was really happy that we were able to coordinate this, because it is really important information to get out to people. And the only last thing that I wanted to add was our phone number. So we do have a fair housing hotline at LawNY. The phone number is 1-866-781-FAIR. So it's 3247. You can also call your local LawNY offices too. And if they don't have the funding to help with it, they may refer you to our regional unit, the fair housing unit that handles these cases. But that is our toll-free 1-800 number that they can call if they have any fair housing issues.
So I'll make sure that that's in the description of this video as well, so people can access that easily. But again, thank you both so much for taking the time to talk through this with us. I know I've learned quite a bit today, and I really look forward to continuing to partner with LawNY.
Absolutely. Thank you.
Well, thank you both. Thank you very much for having us.
Thank you. Hey everyone, so we know that we are without our friends from LawNY and that we are wearing different clothes. We wanted to come back and let you know that right after we had gotten off of that call, we had been talking a little bit off the record with our friends at LawNY, and they let us know that a really important name change clinic is coming up. This is something that is really helpful for our friends in the community who are looking to change their names, their gender markers, really just make their identities more validated on legal documentation. So we wanted to talk with you a little bit about that. Mitch is going to give you all the information. I'll give you the contact information, and then we really hope that it's helpful to you. And if you need help getting it set up, let us know. We will certainly help you do that.
Yeah, so it is a free legal clinic that is going to be completely virtual, focusing on those name and gender marker changes. So it's open to transgender, non-binary, and gender non-conforming individuals who are seeking to legally change their name and or their gender marker on identity documents. So if you're just looking for one or the other, you can still sign up for a 1-hour slot. You must have internet or phone access. The date for this is Saturday, May 1st. It's online via Zoom from 10 a.m. to 5 p.m. You will receive free legal assistance with the name change petitions. And with your gender identity documents, including your birth certificates, you will also receive like free legal advice from them during that. So this is sponsored by a whole group of people, including Planned Parenthood, Ithaca College, LawNY, Cornell, the Volunteer Lawyers Project, SUNY Corning, and the Center for Diversity, Equity, and Inclusion. So Amy, we'll give you that contact information so you can reach out and sign up.
Yeah, so we have the posters already shared on all of our Facebooks. You can find it all over the internet from any of the websites of the places we've just mentioned. But if you don't have access to filling out the online form, you can call 607-273-3667, and they will also be able to help get you set up. We'll put that information at the bottom of our About Us section as well, like we always do. But we wanted to give you a heads up now, let you know, start making some plans. And if you need any assistance with that, feel free to reach out to me and Mitch. Other than that, we will see you next time. Bye, everyone.
Bye.